Welcome to our Need to Know series that comprises all the programs, tools, and processes every CB Apex agent should know and includes most of your frequently asked questions about these items. Please make it a practice to review these videos before reaching out to your OA or manager for assistance, as we hope these series provide a valuable resource to quickly get what you need. Today's topic is on how to work correctly and within correct guidelines when co-oping on a listing that is listed by a limited service brokerage firm. As a full-service brokerage firm, Coldwell Banker Apex Associates are not allowed to list properties as a limited service. Because of that, some of you may not be aware of the rules regarding limited services. For Coldwell Banker Apex, let's have a brief discussion of why, as a listing company, we choose not to do this, and then we'll address the real topic of the day, which is when you're co-oping, how do you take care of your client while also following the TREC guidelines. So we believe that the limited service does not meet our philosophy of putting the client's best interest first. We believe strongly in our value proposition and the value of an educated quality agent who is intricately involved representing the seller. In a limited service, there's limited involvement by the agent. As a listing company, we spend millions of dollars a year to make sure our agents have the latest state-of-the-art technology, ongoing education, advanced training, and tools that are meant to provide sellers with the most qualified agents in the business. And these millions of dollars are Coldwell Banker Apex funds. This does not even include the millions and millions of dollars that Coldwell Banker as a franchise spends on these tools. A great agent can make or break a deal. We have all seen great agents pull together transactions that would never have come to a good conclusion without all the parties being involved and working directly with the agent that is representing them. A great agent should be why a sale occurs. So we believe that a limited service type listing for our sellers is not an option. We are a full service broker. Anytime you make a reduction below the 6%, it needs to be approved by your manager. So don't forget that very important rule. We do have an exception to the rule of not taking a limited service, and that would be for new home partnerships. You may have the opportunity to work with a new home builder who builds in scale, and they may have 15, 20 listings that you would be able to take the listings and put them in MLS at a reduced limited service fee as well as a reduced involvement. If you have an opportunity of that nature arise, please go see your manager and they'll work with you on what we can do. And the reason that is different than a seller selling an individual property or even multiple properties is the builders employ full-time salespeople at their sites. So they do have people that can negotiate and see that the transactions come to a head. So it is a different environment. Today's discussion, though, revolves around the proper way to represent your buyer's best interest when the need arises to show a listing that the listing broker has listed as limited service. First, let's discuss what a limited service listing is. It's a listing that the seller and the listing brokerage firm, through the listing agent, have agreed that the company will provide limited services. They may do no marketing, and they may only input the property into MLS. They may not accompany the client to closing. So there's a lot of variations on what that limited services is going to exclude. However, there is a misconception in the real estate community among agents on what the law allows a listing company to limit in the services they provide. The law and TREC rules are very clear that the listing company must provide the following services and follow the rules listed below. So number one, the first rule is the listing company must present all offers to the seller. They cannot ask the buyer's agent to do this. So if a limited service company asks you to present the offer on the listing directly to the seller, please politely inform them that you represent the buyer, not the seller, and that the law prohibits you from doing this. The listing agent and company can ask you to deliver the contract to the seller, so just to physically get it in the seller's possession, but they can't ask you to present the offer. If when delivering the offer, you may find yourself in the position that the seller asks you to go over the offer, we're finding that some limited service companies are not explaining the fact that they are in all ways the listing company and that they are required to present the offer. Many sellers seem to be under the impression that they have purchased a pay to put on MLS service. No such service exists because the law does not allow for that type of limitation. If a listing broker takes a listing, the law states they must act as the agent in the key areas we are discussing. So how do you handle that at the door when you deliver the offer and the seller asks you to come in and present it? This would be the scripting I would encourage. Mr. Seller, I'd love to assist you in any way I could, but the law is very clear that I'm prohibited from doing the actions required by law of the listing company. You will need to contact the listing broker agent to have them present the offer and review the contract obligations with you. I'm sure they'll be happy to do this as the law requires this from them on your behalf. Number 2 rule is that the listing company must conduct all negotiations. They cannot ask you to, quote, call the seller because they, quote, don't mind. In fact, this was happening enough that the state legislature enacted additional language that prohibits the limited service broker or the firm or the agent from giving the buyer agent permission to talk with their seller, permission to present an offer, or permission to negotiate. Kindly remind them of this fact and the fact that this is taught in every CE class in Texas, so every agent should know this. The third rule that's important is do not during any point of the transaction speak directly with the seller. If you receive an email from the seller, forward it to the listing agent, just as you would with any other listing of any other competitor that you work with regularly in the market that may not be a limited service listing. In the key areas of presentation of contract and negotiation, the listing agent may not abdicate their responsibilities to you. Not only is the agent prohibited from asking you, you are prohibited from doing it. If you are working directly with the seller listed in MLS, you are in violation of the law. So stop immediately and go see your manager. We realize that these listings often bring challenges to you as the buyer's agent. Your intent is to do what's in the best interest of your buyer, and that is always our intent at Coldwell Banker Apex. However, that intent cannot overstep the law. So the TREC rules and the law rule in this area on where your limitations are. So do not in your mind make the overstepping of the bounds the law has set for you as the buyer's agent okay because you're working in the best interest of your client. That's never okay. This video is meant to clearly define your role as the buyer agent on a property listed in MLS under a limited service. The fee the listing brokerage firm has chosen to charge is irrelevant to this discussion, and it's none of our business as an agent or a company, and not something we should be ever talking with another firm about. Antitrust is a serious violation in real estate. Antitrust occurs when you begin discussing commission rates and fees outside of Coldwell Banker Apex. The fees within Coldwell Banker Apex are set by the broker, but no discussion should ever occur outside our own company. What is our business is to see that we do not violate the law because a firm tries to abdicate their responsibilities to us. You represent the buyer, and it's important that you do not do the listing agent's job in any way. In viewing these homes, it's fine to explain that the seller may have limited assistance in understanding a contract and limited assistance in negotiation when talking with your buyer. Some firms use email strictly as a means to pass the offer from one party to the other. This meets the legal requirements, but as a real estate professional, we know a great agent on the other side can do a good job of helping the parties reach a mutual desirable contract, first in the contract negotiations, as well as several other times throughout the escrow period. You are not to discuss fees in any way with the buyer when discussing that a property is limited services and that you're explaining the process. In fact, you don't know what fees the limited service broker is charging, and even if the seller tells you, it's irrelevant. Please keep on topic. The only reason to mention anything to the buyer is to prepare them for a possibility of a slightly different process. If the limited service company follows the rules, in a completely different one if they do not follow the rules and they refuse to do the work that TREC and the state statute require of every licensee in Texas. The reason we've recorded this video today is we've had multiple situations this year where the listing company is not following the trick rules, and our agents have stepped in and done the listing side, which again is a violation of the law. We want to make sure our agents understand where their line stops. I hope that today's series on the limited service listings is helpful in presenting offers the proper way and following the law in all areas when we're working as a co-oping agent within a limited service listing that is on MLS.